Hello, everyone. I'm Kevin Gosztola. I'm the editor of the Dissenter newsletter and also the author of the book Guilty of Journalism, the political case against Julian Assange. It is a political case. We've seen over the last 2 days a fair demonstration by his legal team, by his defense attorneys, Mark Summers and Edward Fitzgerald, that this is a political case. We've seen the way that the government, the United States government, through their representatives in the Crown Prosecution Service, seek to represent the case. And so welcome to this broadcast. I won't take too much time, but I do want to share my response, my observations, having taken in much of the arguments, having seen the submissions that were shared with the court and provided from we saw yesterday, we had the defense team give their reasons for the grounds for appeal. And then we saw the U.S. government through the Crown Prosecution Service give their objections to Julian Assange being granted an appeal. And so, but first and foremost, I encourage you to go to thedissenter.org. You'll find coverage of yesterday's proceedings, the second day. We're putting together a report on the second day with the United States government arguments. We're now waiting for this ruling, this decision that would come down from the British High Court of Justice. Essentially, so everyone is clear, the High Court of Justice will make a decision on whether to grant a full appeal hearing, and that would allow Julian Assange to appeal the authorization of extradition to the United States for activities that press freedom groups, human rights organizations, and civil liberties organizations, and many supporters around the world, as well as individual journalists, have recognized as standard news gathering activities. We're talking about the kind of thing that journalists do every day, especially if they're engaged in national security journalism. National security journalism, coverage of military operations by the United States, reporting from war zones might involve this. Excuse me, I'm having a little bit of a hiccup with my internet connection, but sure we'll come back. Sure it'll become stable. I'm wired, but bear with me. And so let me get in here to this. Let me discuss the prosecutions, the way that they have addressed the issue or the matter of Julian Assange and the actions that he engaged in and what he did, and tried to differentiate it from that of a journalist. It's something that we need to go over. So they give a breakdown. For those who are unfamiliar, there's something called Article 10 in Europe, in the European Convention on Human Rights. And Article 10 largely covers freedom of expression. For Americans, you could draw a comparison to the First Amendment, but it may be a little bit more robust or entail more activity than even the First Amendment would sometimes. I'm not from Europe, though, so I don't want to claim to have a full legal analysis. But the way that we can understand the freedom of expression part of the European Convention is that this would cover journalists, people who were involved in the publications of materials like Julian Assange. And so let's test this. The reasons why the government stood before the High Court of Justice today on the second day of proceedings and made a claim that Julian Assange is a criminal or a hacker or somebody who should be prosecuted is because they say that he was encouraging sources to circumvent legal safeguards on information, that he was providing this information to WikiLeaks for public dissemination, and that this pattern was continued, that WikiLeaks continued to ask people to provide information that could be publicly shared, and they would be able to do it whether it was obtained illegally. Everything I just said is the nuts and bolts of good investigative journalism. There are over 75 organizations, according to the Freedom of the Press Foundation, that have set up Secure Drop, which is a secure submissions system modeled after the system that WikiLeaks pioneered way back in the late 2000s, the system in which Chelsea Manning, the source of the information that is being criminalized in this case, that they created this system. And it's been perfected, improved through Secure Drop. The organizations that use it, Washington Post, NBC News, ProPublica, go down the list. The New York Times is also on the list. These organizations are not in trouble at all for publicly sharing information they obtained illegally, for seeking to circumvent legal safeguards. Legal safeguards is very general. What could that mean? But I take it to mean that there are rules and regulations for information, that this information should be kept secret, and that those sources are not supposed to disclose it to the press. And in doing so, now that journalists have the material, legal safeguards have been circumvented. That's basically all they are saying there. The complicity in criminality is another aspect. They're saying that Chelsea Manning responded to Julian Assange's solicitation of classified materials. Well, she did know that WikiLeaks was a site for publishing classified documents that were of public interest. So certainly, if it's a crime for a news organization to say they accept leaked information, and someone who knows that that publication will share their revelations acts on that, if that's a crime, then we're basically saying we're going to put a whole host of media organizations and journalists out of business. We're going to have prosecutors go after them. So throughout this time, the prosecutors also say Manning was in direct contact with Assange, and Assange was encouraging Manning to steal classified documents and to provide them to WikiLeaks. From someone who covered every stage of the court-martial, the military court-martial in Manning's case, I will say to you that Manning was acting entirely independent of WikiLeaks, making decisions on her own. There's very little evidence in these alleged chats between Julian Assange and Manning. And I stress alleged. It'll be for a trial, if we would ever get there, for them to prove that Julian Assange was actually the person who was chatting with Chelsea Manning. But to say that she wasn't acting with her own agency is a clear effort on the part of the United States to make it seem like Julian Assange is the one who is putting recruits, they say recruited, putting recruits up to stealing this information, hacking information as well. They've put that out there. They've lobbed that Molotov cocktail. They're saying that he's asking people to hack documents. Then there's the furtherance of these acts by Assange, where he's agreeing to help Manning crack an encrypted password hash. That's something we've been told. We've been told password cracking conspiracy. Well, there's no password cracking conspiracy, simply because Chelsea Manning had access to those documents, those classified information databases. That wasn't anything that she needed help going in. The idea that she needed to be able to get the documents anonymously, she's able to download them. She's able to put them on, back then we had CD-ROMs. She's able to put it on any removable media. You could stick a thumb drive in, walk out with it. That was a big deal. That was one of the security gaps that was acknowledged by the US military. Part of the establishment of an insider threat program and the task force that was going to make sure that more sources, media sources, didn't give information to the press was to say, we're going to put extreme restrictions on how soldiers are able to put removable media into their computers. So she could have done all of this and it would have been fair. What they won't talk to you about is the evidence put before them in these proceedings by a former Army criminal investigator, a forensic examiner, who says that the reason why these soldiers are interested in being on their computers anonymously back in this time, and this was in 2010, is because they want to publish movies, or sorry, they want to download movies, they want to download television shows, they want to download music, they want to download software, and they want to put all of that on their computers so that they can access that material and then be on their computers without getting in trouble. It's said to violate the good order and discipline of the military. They're told not to do it by their superior officers in their chain of command. So they wanted to be able to get on their computers with logins, and nobody would be able to tell who had installed this software, put these movies and music on the machines, and made them non-functional, made them incredibly dysfunctional. So this has nothing to do with leaking. This has everything to do with the functioning of a military unit and the systems, and whether they were going to be able to do, what they needed to do. So we continue here. Part of the allegations against Assange involve, of course, the idea that there were the disclosure of names of sources. That's not a crime in the United States. What does the prosecution say to the High Court of Justice? They say there's only a few instances of this. It's explicitly limited to documents classified up to the secret level that had names of individuals in Afghanistan, Iraq, and elsewhere who had risked their safety and freedom by providing information to the U.S. and its allies. Simply put, there are no examples, there is no evidence that anyone was ever killed because of a WikiLeaks document. None whatsoever. Whether we're talking about the cables or we're talking about the war log documents. You continue here. This idea that Assange is seeking to recruit and work with other hackers is grafted on back in the summer of 2020 to try and salvage a case that looks pretty clearly like it's criminalizing journalism too much so that they need to go to Ziggy Tordarson from Iceland, who is a sex offender, someone who's been convicted of sex crimes against children, and somebody who is a pathological liar, wholly unreliable, and spoke to a journalist and said that he was making up this allegation about Julian Assange as it related to hacking agencies in Iceland, and even the targeting of bank information that forms a part of this indictment. Yet none of that has been withdrawn. It continues to be maintained by prosecutors, and they're with a straight face. They stand before UK judges and continue to argue that all of this is legitimate and could be proven in court in the United States, even though it is without basis. And I could suggest to you that some parts of the indictment might just be there so that they could win extradition, and then they could withdraw it because they don't want to have to face a U.S. judge who is going to be able to unpack it and see what's phony about it. And there's parts of it that a judge would probably entertain in the Eastern District of Virginia because it's got the nickname Espionage Court. But if you don't have evidence or facts to back up these allegations, it's going to be apparent fairly soon. And so, they'll let you argue anything, but you got to at least bare minimum put together some kind of a case here. And they're just throwing anything they can against the wall and trying to see what sticks, because they know that there are some very clearly delineated rights that Julian Assange has that are at risk of being violated as a result of their extradition request. So thank you, everyone, for joining. I'm just going to check in with you. I like to check in with the people who are viewing throughout the broadcast and just say thanks. I'm glad that everybody can hear me clearly, see me clearly. The internet connection is working. And so I'm not, it's not clear to me what you're asking here, but if you want to tell me what you're saying about who made if you're asking about who initially contacted, Chelsea's the one, she reaches out to WikiLeaks. WikiLeaks is interested in having documents published by WikiLeaks after she finds that the New York Times and the Washington Post and Politico and a couple other publications are not going to publish the materials. Thank you, Groen, for the compliment. Yeah, my book, Guilty of Journalism, The Political Case Against Julian Assange, is available over at the project-censored.org website. You could get it through Amazon. There's both an ebook and there's also a book that you can hold in your hands. And again, thank you to everyone who's picked up a copy. I'm nearing the 1-year anniversary and thinking about marking it. Hopefully, I won't be marking it with an actual extradition of Julian Assange to the United States, though it occurs to me that the timeline could match, and that's frightening. So I've said a little bit about the prosecutors. One more thing I want to say here is that when you follow their arguments, what you notice is they'll say things over and over again to judges that the intent is to confuse the judges. And then when they are confused and don't know, what it has effectively done is made them go, oh, well, let's just let it be sorted out at trial. Let it be sorted out at trial, and then we'll figure it out. Everything will be sorted out then. So that is, I think, a tactic that they really want, because if they don't murk the waters, then there's a very good chance that these judges start to pick apart their arguments in much the same way that Julian Assange's defense team has done a good job of picking apart these arguments, the same way that journalists like myself we've picked apart their arguments. We've also had press freedom groups and civil liberties groups do a good job of recognizing what is at risk here. I've got some slides, but just bear with me for a moment. I gotta get up for just a second. I'll be right back. Doing a show solo, and I just wanted to control the noise that surrounds me in this space here so you can get the best possible analysis and breakdown of these proceedings. So I thank you for your patience. What I have on screen here is a tweet, and there are several. I encourage you to go to the Free Assange News Twitter page, and there are 2 threads. There's one for each of the days. This is in partnership with Truth Defense, a group in the UK, and Mohammed Almazi is part of Truth Defense, and Mohammed Almazi was in the courtroom for the Dissenter newsletter, and I'll be sharing his article on the second day very soon. So here, during these proceedings, we got to see raised the Vault 7 materials. This is called fresh evidence. The publication of Vault 7 was, to put it colloquially, what led to Mr. Pompeo, as it were, going off the deep end. Fitzgerald explains he's making the statement that WikiLeaks is a non-state hostile intelligence actor within a month of the Vault 7 publications, and Julian is not actually charged for these publications, which were made years after the publications cited in the indictment. The point there being that Vault 7 is uncharged misconduct at this moment. Pompeo then goes on to instruct illegal surveillance of Julian and his lawyers, who he was an asylee in the Ecuadorian embassy. So what is being outlined there is that this Vault 7 misconduct, I don't think it's misconduct in my book. I'm not out to charge Julian Assange for it. But in the eyes of prosecutors, this is an action when they get to sentencing that they can charge Julian Assange with, or they can use it to add enhancements to Julian Assange's conduct. And he's actually charged with a computer crime offense where they have the ability to add a terrorism enhancement. We just saw Joshua Schulte, who got 33 and a half years, and he was sentenced to prison with this terrorism enhancement that was applied. And he's under special administrative measures as well, the way that he's been strictly handled in a detention facility while awaiting trial. And then now those restrictions will carry into his federal prison sentence. This is the kind of treatment we could see against Julian Assange. Going back, so if we look at this next slide here, it's clear in the Yahoo News article, which they asked the court to admit as fresh evidence, it is the Vault 7 publications which resulted in Julian being charged for the first time. And the defense submissions explain that there was an uncontroverted body of evidence before the district judge, that's what DJ means, I'm not talking about somebody playing music, unfortunately, that if Mr. Assange were convicted after his extradition, he faces a sentence for conduct that he has not been charged with nor extradited for, potentially even conduct in respect of which he has been acquitted. And following a judicial fact-finding exercise on the balance of probabilities, it could be based upon evidence he will not see and which may or may not have been legally obtained. So we know he was targeted with this surveillance operation, a spying operation against the Ecuador embassy. Maybe there's supposed conduct there that they want to charge him for that they found while they were targeting him in the embassy. While speaking with his lawyers, he was meeting, having attorney-client privileged conversations. This is even after he was indicted. After he was indicted in December 2017, you still have UC Global with the support allegedly from the CIA that Julian Assange is being targeted. And then you have this fact that is being raised here that if he is extradited, he's exposed to additional charges that have not been presented to this court, which is to say that the Crown Prosecution Service hasn't fully represented the scope of what the U.S. government thinks are crimes committed by Julian Assange. So there's a duplicity here. There's a deception that goes beyond just some of the lies and the twisted nonsense that you see expressed in the courtroom. They're also hiding what they have in their back pockets that they would use against Julian Assange during a sentencing portion of a trial. And so we go on here. We go on here to say that it's a flagrant denial of justice. It is grossly unfair to punish somebody for something they have been acquitted of, Fitzgerald insists, adding that we're dealing with a fundamental principle. So what Fitzgerald is basically saying there is if you go through a trial and then you're convicted, you got all these guilty verdicts against you, but none of them have anything to do with this other conduct which you could have been charged. The fact that you could then be at sentencing hit with some sort of multiplication of your prison sentence because of alleged crimes that you actually weren't charged with committing, that is a violation of rights. That you're not on notice. The accused is not being fairly treated in that respect. And so the high court should reject this extradition because of how sentencing would bring in the Vault 7 publications potentially. He explained, Fitzgerald, that the U.S. government has made clear that they would keep the door open in relation to seeking Julian would be sentenced for offenses that he was not convicted or charged with. So then we go on to this exchange, and there's Judge Victoria. It's actually Dame Victoria, if you care about titles, but I don't particularly. Does it extend to the point that it could apply to every criminal case involving a criminal charge? Fitzgerald said, yes, I suppose what one would have to do in every individual case is to identify there's some realistic case that this might happen. Judge Victoria, you say the Vault 7. Fitzgerald, yeah, you can say the system is bust and that it might affect me. My lady, we've identified a cause for very direct concern. Again, no undertaking from the U.S. government. No, we won't rely on any other conduct, or we will not invite the judge to. So we respectfully submit that this is a serious, arguable point. So no assurances, again, that word that has come up often in this case in order for the U.S. government to dodge the reality of these allegations that are being put forward and what it entails. Because there's a way that when you charge people with these criminal acts, that they get treated in the prison system, when detained, when prosecuted. It's just, we're being treated like children to see that the government officials and these prosecutors would come before the court and pretend that they're not this brutal and strict and relentless in the way that they mete out justice. So this is a huge issue, and it's one of those things where you're thinking of uncharged conduct that could eventually lead to a potential death penalty. Maybe we don't know. Could that be applied? And there was a particular exchange that is remarkable where the judge went back and forth here. Let's see. I think what I have here is a different issue that I'll get to. But there's a remarkable exchange where they're discussing the death penalty and how the U.S. government has not assured Julian Assange's legal team that he will not be charged with the death penalty during a trial, because it's not there right now that he would be, but they can apply it during trial. So that is something that is barred under extradition statutes in the United Kingdom. Under the law, there's no death penalty is something that you're not supposed to expose anybody to when they're extradited to another country. The U.S. government isn't trying to even say that Julian Assange won't get the death penalty. They're just ignoring it and hoping that the high court judges do nothing about this glaring aspect of the case. But it could work in Julian Assange's favor because, yet again, this oversight, the way in which, like earlier, they wouldn't tell the judge at the district court level that he won't be placed in special administrative measures. They wouldn't say that. And so now they're in another position where they're not saying he won't get the death penalty. Looking at this, here's another aspect I found remarkable. This is the fact that we're seeing a discussion among the judges about Manning, Chelsea Manning, and how under the European Court of Human Rights, she might be protected as a whistleblower. So Julian Assange's legal team says that her whistleblower disclosures would be protected under the freedom of expression part. That's Article 10. Once the European Court concluded that, it's completely superfluous that the court would then consider whether this article would protect a publisher from publishing that very material. There is no authority which suggests the European Court would act in that way. So think of this logically. The whistleblower is protected. If the whistleblower is protected, then absolutely the person who publishes that material has to be protected from prosecution and can't be extradited to the United States. So now we see that someone who, by the way, has established herself as a whistleblower, has her own memoir that was shared with the press, gets published and talked about in the press as a whistleblower. The U.S. military lost this battle. They wanted everyone to think she was some kind of treasonous soldier who helped terrorists by sharing information with WikiLeaks. Well, how badly that went for them, because everyone sees her as a whistleblower. And that's making it to the high court in this case. And they're going to reflect, and it will be part of their decision when we get it. They'll have to make some kind of assessment of Chelsea Manning in order to make a determination on how to respond to this extradition request against Julian Assange. I find that really important to the chain of events that we've seen playing out. Here's another thing. The judges asked the U.S. lawyers for the sentencing remarks in Chelsea Manning's case. Smith was one of the government attorneys, tells the court they don't consider Manning to be a whistleblower. They don't consider a case to be that involving whistleblowing. I mean, of course they don't. They represent the U.S. government. But the judges want the sentencing remarks from a military case that has long been decided. they want to look closely and see, and I assume they want to match it up with what the defense attorneys are saying about Manning, try to figure out, where exactly they're supposed to be as far as their understanding of Chelsea Manning and her acts. And they're going to do their homework. They didn't issue an immediate decision. They're going to go look at it. I'm not saying that's hopeful for Julian Assange, but finally an appeal, and the judges at this level are going to give this some consideration. And I don't know that I'm saying that that's a positive, and obviously that's not a negative, but it's just a part of reflecting on these past 2 days. So I'm going to start winding down this discussion of the proceedings that happened in the past couple of days. I am going to be on Status Coup with Jordan Cheriton in a couple hours. I have to go edit and work on the article for the Dissenter newsletter from Mohammed Almazi and his coverage. He did some excellent work. So I'll close here by saying a little bit about media access for this appeal hearing. And in a case where we know that this is a possible decision that will have huge implications for world press freedom, what we saw from the UK courts was appalling. What we saw from them was the fact that they think that allowing press access to these court proceedings can be an afterthought. Journalists can be a nuisance. Journalists can be cast aside, or they're security threats. They just might be people who would be out to violate the rules, and we have to be able to control them. And that's the way things went. For the first hearing in Julian Assange's case, was outright denied access to the remote feed. I was told that I could not watch the proceedings from the United States. And the reason why I was not allowed is because I'm not in England and Wales. So if I had been in England or Wales, I can't be in both at the same time, obviously. That's not geographically possible for one person to do. But if I was in any of those jurisdictions, they would give me a link. But if I was in England or Wales, I probably would try to go to the courthouse. The reason that you would give a feed would be to promote access for international journalists, and then they don't have to travel thousands of miles to get to the courthouse. And you would do it because you recognize that Australia, especially, and people from the United States have a particular interest in the outcome. The U.S. government is prosecuting Julian Assange in an unprecedented manner and making claims that will have profound impact on the future of not just freedom of the press, but First Amendment rights. In Australia, one of their own, an Australian citizen. The Australian government backs him. The Australian Prime Minister says he should be freed. Julian Assange should have the charges dropped against him. This is what they have demanded the Justice Department do, and Joe Biden and Attorney General Merrick Garland and others have just disregarded, just put it off to the side. It's no big deal. But that should have factored in, and even though the court considered it, they basically said, there's going to be enough journalists from Australia, enough journalists from the US, enough journalists from various other countries here in London. So we do not need to accommodate more journalists outside of the United Kingdom. Oh, and by the way, if we did, we would have this problem where should anybody violate the rules, we cannot enforce the court order. But yes, you can. You can enforce the court order. If you believe that somebody has violated the rules, you know who you have granted access to the audio-visual link, and you can simply deny them future access. You take the link away from them. You could change the link. You could send everyone a new link that was different from the old link if people are using that, but that's not how it should work. There should be a new link every single day for proceedings. And we were only talking about 2 days that they needed to figure this all out. It wasn't a 4-week hearing like the main extradition trial that took place in September 2020, in which they had dozens of journalists that were on the system following proceedings at the district court level. It's entirely possible for them to accommodate people. They choose not to. And I got a quote from Seth Stern, who is the Freedom of the Press Foundation's advocacy director. And he put it well. This creates or breeds distrust in the High Court of Justice. It feeds into conspiracy theories about the High Court and what they might be doing and why they don't want journalists to have access, but also deprives us of accurate information. If you're not doing this so we can access these proceedings, then I'm going to just go off what I'm reading on social media, reading from other people. I'm going to filter it through them. I won't be getting it directly. And then that's how conventional wisdom starts to take shape. And we start to have conclusions that might not be based on what was actually said in a courtroom. This is why you shouldn't have a quota. It shouldn't be, oh, okay, we got 25 or 30 journalists that are going to be there. That's good enough. No, there is no number that's enough. If you can accommodate 300 journalists, you do. If you had some way to accommodate 500 journalists that want to know what's happening in Julian Assange's proceeding, you make that happen so that people can follow the case. You do that because we're living in the 21st century, and we all know that the technology exists to support it, and we all know that you pay lip service to these ideas of open justice, and it is entirely possible to do it. Finally, Mohammed Almazy was there. He was there at the British High Court of Justice. And I need to stick up for him as somebody who's doing fantastic work for the dissenter and for me. And I hired him, and people who have donated, I'm paying him with money that people gave the newsletter to make what he is doing possible, to compensate him fairly for doing this hard work. And it's really difficult work to get up early in the morning, to get there to court, to sit through these proceedings, to tweet updates constantly throughout the proceedings, to write in between, to find the way to get lunch, to then, after everything is over, go write an article. Mohammed's also producing panel discussions. In just 20 minutes, you can watch a panel discussion that Taylor Hudak is hosting again, or had hosted yesterday. I believe there's a second day. Chris Hedges was part of a panel discussion yesterday. Craig Murray was there. Joe Loria, Kathy Fokin, all these people who were there as independent journalists following these proceedings. So he's doing all kinds of amazing work that it taxes you and makes it really hard for you at the end of the day. You're totally exhausted. I've been there. I've done this before. I'm in a little bit better shape now, but I've been working hard during these proceedings, keeping myself busy. And Mohammed was at the High Court of Justice in his seat. He had his press ticket. He came early. He got his spot. And someone, a court administrator, a court officer, comes and says, you have to get up. Why does he have to get up? The Associated Press is here. The seat is for someone from the establishment media. The seat is for prestige media, and you need to get up. And you could go to the public gallery. You can go to the public gallery, and you can sit there. In the public gallery, there are no tables for your laptop. There are no outlets so you can keep your laptop from dying. They want you to be, I guess, writing with some pen and paper, old school, like some classic journalist from the Great Depression. And you also can't hear. You can't hear because the audio is not reaching many of the people who sit in this section. Go read complaints from Italian journalist Stefania Marizzi. Go read complaints from Chip Gibbons. So he's told to leave, and he goes to the basement of the British High Court of Justice. and he's in the basement, and he's not getting some special way that he can follow court proceedings. He's going to follow it on his computer. He opens his computer, he watches the remote feed, just like I wanted to do from the United States, and just like he could have done if he had stayed home in London rather than traveling to the High Court of Justice. So this is what happens to you. This is what they were doing. It's very disrespectful to reporters, and it makes it look like they really don't care about satisfying any principle of open justice. They could just shuffle journalists around to places. They don't have space for everyone. They're not appropriately making sure that those who are interested can follow this case. And the ones that are flippant about it and don't care that much and come late, they'll just give you a seat and they'll yank some other independent journalist out. And that independent journalist probably knows way more than they do. I guarantee Mohammed knows way more than that Associated Press reporter does about the Julian Assange case. And yet he was told to go to the basement, get on his computer, bury his head in his laptop, and follow the proceedings in that manner. Unless he wanted to go to the public gallery, and then he could sit there and torture himself by not being able to hear the people who were only a few meters in front of him and not have any idea what was actually being spoken to in the courtroom. So that wraps it up. Those are the 2 days. I will be back with a update, a full broadcast when we have the decision from the High Court of Justice. We'll try to remain hopeful, but we all know that the only thing that can end this is a political solution. It's a political case. As I say in my book, wrong way, right there, the political case against Julian Assange. And you need politicians, or you need the people who are in government to end it. The courts are not going to end it. The courts see that there's a veneer of legality over it, and they're treating it like this is a serious and fair and impartial prosecution. So they're engaging with it, and all the defects they believe are not because of bad faith. It's just because they're defects and they can deal with them, but they'll take them as they come and they'll extradite him all the same. So in order to save Julian Assange and save freedom of the press, save investigative journalism or national security journalism, we have to keep ramping up pressure. We have to tune into broadcasts like this. We have to support independent journalism on the case. We have to support calls from organizations, law professors, whatever they might be. We have to be out there protesting. We need to be telling the Justice Department and Joe Biden and everyone in Congress at every moment that this is wrong, and we do not want to destroy or undermine the First Amendment. We want to save it. We want to protect it. We want no race to the bottom. We want to protect world press freedom. We want people to be able to publish information about corruption in governments and not live under threat that they are going to be extradited and prosecuted either by the US government or a European government or some dictatorial regime or anybody else out there that thinks that they can enforce secrecy laws against foreigners, people who aren't even supposed to follow their laws. So thank you for tuning in. I'll put this up here. It is a link to the newsletter as a reminder to all of you to become subscribers, support this work, this independent journalism. It's not just on Assange. There's stuff you'll find there on press freedom stories outside of this, as well as whistleblowers and then government secrecy. So go there. And again, I will be back soon with more on Julian Assange's case. But until then, thank you very much for all of your support, and take care of yourselves.